So you guys probably know Sameer as the co-author of Unshackled, um, but he's also a lawyer with over 2 decades of experience, and just someone that I've really enjoyed working with just on my own immigration journey. So Sameer, I'm really excited to kick off the very first AMA of the community with you, um, and thank you so much for being here.
I am so excited. Thank you for setting this up, and I can't wait to get started.
Yes, so these are the founding members of the community. We've had calls with pretty much all of them by now, and we kind of handpicked these people because they've shown interest in pursuing one of the talent visa routes, or in general, in just taking charge of their immigration journey. So these are very highly talented and driven people that you're seeing on the call. So to kick things off, I'm just going to start with this, two questions, Samir, and then we'll turn to the audience for their questions. First is, in a few sentences, can you explain what the O-1 visa is and what the EB-1 visa is?
Sure. So the O-1 visa is a form of temporary employment and status permission, basically. So if you want to have permission to work and live in the US and you need it in the next 2 months to go work for a company, for example, the company needs to sponsor you for a visa, right? Generally, that's a H-1B. But another type is the O-1. So that's how it works. It's temporary and it's kind of a faster turnaround, right? Lasts for about 3 years initially with 1 year extensions after that. The EB-1 it's not a green card per se, it's permission permission to apply for a green card in a certain category, right? In the fastest category. So it's very much like the O-1 in terms of the requirements, but they're harder. And once you're approved, doesn't mean you'll get the green card right away. It just gives you permission to apply for the green card when the priority date is current. But the benefit of the EB-1 is that your priority date will be current, obviously much faster than it would in EB-2. So that's the high level difference. I hope that made sense.
Yeah, it's very helpful. And I think the keyword here is O-1 is temporary. It's a work visa. It's for 3 years. You can extend it, but you still have to apply every year to extend it, right? After that. And so that's there.
Generally, yes. Yeah.
Yeah. And the EB-1 is not a green card. It's permission to eventually get a green card. It's the first step in the process, kind of getting the approval for the EB-1.
You basically have to show that you are qualified to even apply for a green card. And so there's
right.
different kind of different categories of classification, right? And qualifying. That's one of them.
And everyone on the call, I can say, is Indian born, I believe. So for Indian born immigrants, EB-1 as of now is the fastest way because the retrogression, the date is February 2022. So if they apply today and get it approved today, does that mean they have to wait a year to apply for the green card? What does that look like?
That's hard to say. Probably that's a good estimate. The thing is, these dates, the dates that are current under the visa bulletin, they jump forward, they jump backwards, right? And they're all based on projected demand, which is kind of recalculated every month. So for that reason, it's very difficult to predict kind of what is the date going to be when you're ready to apply. I would say a good estimate right now would be, it's actually a little more than a year. I think it's almost 2 years at this point in terms of how long the wait is. I would say it's at 2 years-ish right now. Honestly, it might get a little worse. The number of EB-1 applications is on the rise. And so what that might mean is the demand for EB-1 numbers is also going to increase, which will pull the dates even further back. So the time definitely is now if you're ready to do it. Yeah.
Awesome. So now I'm going to turn to the attendees and make sure that their questions are answered. I'm going to start with the question from Dave. So Dave says, "Hey Sameer, great work on the YouTube videos. Thanks for your effort in building resources. First question, Sameer, what is your immigration story or your parents in the US?"
That's a nice softball for me. Thank you so much. No, it's I have a kind of a unique story. And my story is my parents were actually living here in the US before I was born. They were married. My dad came in the late 60s to do his master's in civil engineering at Berkeley. Then he got married and brought my mom over. They were living in LA, and my mom got pregnant with me in her third trimester. She was like, I don't want to be here. I don't want to give birth here. I want to go back to my mom. And she went back to India, and she had me there. And then 6 weeks later, turned around and flew me back halfway across the world, back to LA. And for that reason, I had a green card for 30 something years until I became an immigration lawyer and applied for my own citizenship. And I remember when I was a kid having to go to USCIS, we called it INS back then, stand in line and try to convince them that they kept misspelling my name on my green card. And I kept having to, figure out a way to get them to correct it. I felt like I was asking them to do something that they didn't want to do. And that's kind of when I realized that I enjoyed working with INS and helping other people kind of go through this process that I had a little bit of difficulty with.
Yeah, and I remember, like, I mean, when you first shared this story with me, I was actually quite surprised that you were not a citizen by birth. Like, you also went through the process like the rest of us in a way. Thanks for sharing that. The next question, actually, I think is something that a lot of people on the call might want to know. How can one convince an employer to look into the O-1 instead of the H-1B as a potential work visa?
That's a good question. The O-1, I've worked on the corporate side for many years, and in fact, that's what I did mainly for like the first, 17 years, 16 years in my practice, right? So the companies are, especially at higher volume, bigger companies, like they feel like they have a responsibility to do the most kind of like straightforward things, try to save cost as much as possible. They feel like they have a business responsibility to make sure things go smoothly. Okay. Secondly, they work with law firms that deal with an immense number of cases, very high volume, and they have to kind of get things turned around very quickly. So the O1 is not kind of aligned with either of those. There's a lot of unpredictability in the O1. It's super specific on the person rather than it being a fairly straightforward set of, requirements that apply to everybody, like the H-1B. And then depending on the law firm, the lawyers, if they don't have a lot of experience with them, can be a little like scared of them. And then the way they communicate their fear of O1s is by saying they're very hard to their HR contacts, and then they scare the HR contacts. So that's like kind of the story behind why O1s are not utilized very often unless they're like super obvious of a solution, right? I don't see that changing, especially at the higher volume companies, but I think in my experience, startups and kind of more earlier stage companies are more willing to do whatever it takes because the leadership is involved and the leadership likes to think creatively about recruiting and retaining top talent.
I think on this call, I would say a lot of people are probably not working at startups. If I remember from our calls, they are working at medium-sized to big tech companies.
But if they're doing that, then they're probably already on an H-1B, right? Now, O1s are like a good solution for somebody who hasn't gotten an H-1B yet through the lottery. But if you have an H-1B, what's the point of getting an O1, right? It doesn't get you to it's just another work visa, but you already have a work visa, so why would they do that, right? So in most cases, it doesn't make sense.
Since we're talking about the H-1B, I have a question here that I think also you've probably been asked a lot is like, what are some ways you can, I believe, make money besides your regular income on an H-1B and on an H-4? I saw the question for both.
Yeah, I mean, it's really on any visa, like what can you do? What is considered work, what is not, right? And in the investment context is what is passive. If it's more passive, it's not work. If it's more active, it is work, right? And whenever you're doing work, you need permission to work. You just think of it that way, right? So you want to do passive stuff. And what is passive stuff? It's just investing like in stocks, not day trading, but just like your typical, maintaining your investment portfolio with stocks, purchasing rental property, and just investing in rental property. And, if you're, making money you're obviously making money off the property. If it's an investment property, it's a rental property. So you may want to have a property manager who just kind of does that stuff for you. So they're actively managing the property for you. So it's not considered work, but I'd be less concerned about that because it's your own house. You own the house, right? So taking care of your house is arguably not work, right? It's when you start getting into stuff like Airbnb and really kind of running a sort of business, out of your property, or renting a car through Turo or things like that. That's when you want to be very careful and make sure you have somebody doing all the day-to-day communications with your guests, with your tenants, with your vendors, with your cleaners, with your, anybody coming in to work on your property, things like that.
I mean, the thing is, I would think USCIS themselves have not published any articles on this. Hey, this is what you can do. This is what you cannot do. Like, they haven't really done that.
No,
so you just extrapolate.
No. We have to extrapolate. They have a set of rules that they've used for the last 50 years, before any of this was ever at issue. And we just have to kind of figure out, like, how do we interpret those rules and apply them to today's world?
Like blogging and content creation, being an influencer, earning money from your YouTube channel. These are very nascent things. Definitely not there in 1990 when the law was written. So what's your advice for people who want to make money through that?
I mean, if I were to get into the mind of USCIS officers, and I have recently, I had like a really, I wouldn't say, it was a pretty traumatic green card interview last week where I had a super, strict officer ding somebody for something very minor. But it's because they were getting paid, right? They were getting paid for what they were doing. And in the grander scheme of things, it was such a small amount, it shouldn't have mattered. But it's very black and white. Immigration law is very binary. Either you're doing it or you're not. And so that's why you have to be very careful, because the penalties for breaking immigration rules, it's called immigration fraud. That's what they call it. They're basically saying you're misrepresenting what you want to do on your visa. That's immigration fraud, and that's a lifetime ban into the U.S. Right? So it can turn very strict very quickly. So that wasn't your question. It wasn't sound there. I'm sorry. What was your question? I kind of went off on a tangent.
No, that's, I think, helpful as well to hear.
Yeah.
A little scary, but helpful to hear.
Yeah.
Which is, my question was, if you want to make money through publishing a blog,
also like content creation,
creating a YouTube channel, content creation.
So I guess, like, even though, like, you can technically be working and not make money and still be working, I would say in this context, like, if you're making money off of any of those activities, you're working. If you're not, you're probably okay, because it's like you can also just put stuff online and it can be a hobby, right? It's not necessarily work. You're not like taking a job away from somebody else. But the minute you start monetizing your work while you're physically in the US and you don't have permission to do that, that's when you cross the line.
Right. And so you said physically in the US. So can they leave the country, work on something abroad, and then come back and earn royalties or some passive income from that?
Yeah. Where are you when you're like performing the activities, right? If you're in India, when you are doing all of that, and then when you're in the US, you're merely just collecting royalties off the kind of activities you conducted in India, that's okay, right? Make sure you keep good records. But the minute you do one activity here in the US, then you've opened the door. At that point, there's no turning back, right? So you just got to be very, very careful.
There's actually a follow-up from Anirudh on this, which is, what if I offer services in India remotely from the US?
So where are you? The key word is you're from the US, right? So
but the services are offered in India. Does that make sense?
You are physically in the US. So think about, you're physically in the US, and therefore US immigration has jurisdiction over you when you're physically here. The whole point is where you're physically located, right? So if you're physically located in the US and you're working, it doesn't matter where the services are being performed, you are working. Then you need work authorization for that.
Right. So I think the two things are, either make it a part of your work, if you can, like if you're working at a startup and if they're open to expanding your job responsibilities. It's not common though. Or leave the US and then work on do the active work abroad, and be very careful of not doing the active work when you come back. So just to wrap up this topic, Ranjit is asking, where does USCIS say which rule states active or passive activity? Because there is active or passive is from IRS, there is nothing on USCIS, which is what you said, right? Like there is nothing on USCIS.
So understand that there are, when you're in immigration, there's actually 3 different departments that you interact with, right? There's Department of Homeland Security, under which USCIS exists. There's the Department of Labor, which administers like the PERM process for your green card. And there's Department of State, which are the consulates. Like generally speaking, that's kind of how it's laid out. So the rules about passive and active income fall under Department of State rules. They're called the Foreign Affairs Manual. I don't have the site in front of me, but that's where that's where the rules are laid out. Okay, and generally, like USCIS defers to those rules in terms of how they interpret passive versus active income, but they don't have anything of their own.
That's a lot about passive active income. So the last topic that I'm kind of seeing on the thread here is if I'm on an H-1B, which a lot of the people on this call are, by the way, and I'm working on my PERM application for EB-2, is it still worth pursuing an O-1 or should I just go for the EB-1 directly?
People sometimes think like the O-1 is like, I should get out of H-1B, go to O-1. There's something good about the O-1, right? And I don't think it's like a one-size-fits-all answer, honestly. Like, you can go directly to EB-1 from H-1B. Having an O-1 does not make your case stronger for an EB-1. It doesn't. I mean, it might shade the officer a little bit in your direction from like a subconscious perspective, but there's nothing in the rules really that says they're going to give you that much more of an advantage, right? For the O1, it might give you a tiny bit of deference, not the amount of deference that makes it worth it to go to an O1. Now, what the O1 can give you, it can give you some other benefits. So don't just do it just for an EB1. That's usually not the best reason. I won't say always, but usually not the best reason. But what if you want flexibility? What if you want to start your own company, right? Or what if you want to kind of do different things? You want to freelance. Like the O1 actually gives you a lot more flexibility in the terms of your employment. And then that would be a good reason to go to O1. Or what if you're running at an H-1B time and you haven't gotten far enough in the green card process? That'd be a good reason. And you can do it if you want to because you feel like it'd be nice to have the O1 to go to EB-1, and then fine, you can do it. You can do that for that reason, but a lot of companies are not going to agree to do that for you just for that reason.
And briefly talking about the cost of the O1, just the lawyer fee, would you say it ranges anywhere from 5 to 15K with a 10K average?
Yeah, around there.
So $10,000 lawyer fee, and then there's $3,000 premium processing. So it's it's a pretty sizable amount. Okay, so you're saying go for the O1 over EB-1 if you want flexibility with your job. If you're starting a company, a lot of founders use that. Or if you just want to maybe slightly fast track your EB-1 process, because a lot of the evidence can be reused for the EB-1 regardless anyway, right? In the future. I have another great question from Anirudh on this thread, which is there is something called the EB-2 NIW that a lot of people, based on my research, don't really know about. So give a quick one-line brief of what is that, first of all.
Very popular nowadays for good reason. They've become easier to get. It's the other way to petition for your own green card. The EB-1 being the first one, the NIW is the other way to do it, so you don't need a company to do it for you. It is an EB-2, so it's not going to get you a green card any faster, but what it will give you is your own I-140 that's not dependent on employment with a company. So if you want to switch from company A, where you have an I-140, and you want to go to company B, but you're like, God, it's going to take me 2.5 years to get an I-140 with that company. That's kind of like, it's a bit of a chilling factor, right, in changing jobs. The NIW will give you your own I-140. So you can go to that company, and if you, somehow by the miracle of grace of God, you're current, you can just apply to adjust your status on your own I-140 without having to wait for the company's permanent I-140 to come through. Sorry, this is not one sentence. I can't do an NIW in one sentence. But the gist of it is you have to show that you work in an area of national interest. Okay, usually pretty easy to show. The hard part is showing that you are well positioned to advance that national interest. So it's kind of like O1, EB-1 level stuff, maybe not as much. But you have to show there's something kind of special about you that makes it especially incumbent and kind of emergent for the U.S. to say, you know what, forget the perm process. Just let's just give you an I-140 because we need you to do these things that are in our national interest. So they've made it a lot easier for those in STEM fields, especially if you're starting companies.
But you still need an employer. Until you get the EB-1 or EB-2 NIW, you still have to have an employer in the US, right?
If you want to be here, right? I mean, the NIW doesn't give you any permission to live here or work here. It just puts you in line for the green card, right? But in order to stay here, you have to have some reason to be here, usually a sponsor for a visa, like an H-1B or something like that, right?
Right.
So until you get the green card, you need an employer to kind of keep you employed. But for the NIW itself, like once you get your green card, you don't have to go work for somebody like you do under the normal EB-2. You can work for yourself as long as it's like in the area of your expertise.
Right. And so EB-1A and EB-2 NIW are the only self-petition green cards. EB-5 as well. That's the investment visa. But these are the three ones, right, that are self-petition. You can take care of yourself, right? So we actually cover the EB-2 NIW in a chapter in Unshackled. Hopefully when you guys get the book, it'll have a lot of details there. Anirudh is asking about early stage startups that don't really know a lot of the immigration process. How hard is it for them to sponsor an immigrant for an EB-2 PERM?
It's not too bad. It's pretty much the same as it would be for any company. I think they just probably need a little bit more hand-holding from their immigration law firm through the process, because there isn't anybody kind of with expertise within the company managing the firm, right, and keeping them on their toes, like you would at a bigger company. But I don't think size of the company really matters when it comes to sponsorship for PERM.
Manoj is asking a very interesting, maybe slightly sticky question is, can we challenge USCIS to provide clear guidance without a lawsuit? Currently, business-related activity is interpreted without guidance for work visa candidates.
No. No, and that's why we did Unshackled, right? I mean, the rules aren't clear. There isn't any information out there. But you have to, I mean, the other reason we did Unshackled was to remind people that the immigration system wasn't built with you in mind. It was built with, labor market protection mechanisms and motivations in mind. It's more about how to keep people out than it is about how to let people in. So if that's and that's true of almost every country, right? So if that's true, then what interest do they have to make the laws clear, as clear as day for people to understand? That end, I would say no law in any area is really that clear. This is just the area of law that affects you guys, and I guess that's what keeps us lawyers in business. Sorry. So no, you cannot challenge government to provide more clarity on the lawsuit.
Without a lawsuit, you mean? Right?
No, you cannot sue the government to say make this law clear. You have to show, whenever you sue the government, you have to show that you are suffering some sort of damage, right, as a result of their actions. Right. So something tangible.
I mean, this is a tangential question, but I think important to ask is, how can people get involved in this at all? Like, a lot of immigrants have asked me, how do I get involved in the movement, the activist movement of trying to make laws clearer or be more favorable to immigrants? Where can they go voice their opinions?
The way laws are changed, they have to be written by Congress, right? So it's actually not USCIS's fault. USCIS falls under the executive branch, right, under the president, right? So they're charged with executing the laws as they currently are. So that's what they're doing, right? So if you want the laws changed, then you have to go to the legislative branch, which is Congress, and lobby them. And so talk to your local U.S. representative or your senator and make your thoughts and your voice known to them. And that's the way to do it.
And you do that just by calling up their office and then
call their office, email them. Yeah, I mean, just literally call them. That's what people do.
And I think this is actually culturally, there's a difference in the US versus, say, India. I think in the US, I've seen it's quite common for people to just call a politician's office and tell them. And they're more receptive as well in some cases. I've heard of friends who.
Well, this is a very normal thing. So think about how politicians function. Okay, at least here in the U.S. So what is the number one thing they want? To serve the country. That's number 3, right? Number 1 is to stay in power, right? They want to be reelected, right? Now maybe they want to be reelected so they can serve the country more, right? So it can be like a means to an end. But they want to stay in power. So what do they need to stay in power? They need to be voted and re-voted in, right? So it's very important for them to stay kind of on top of the tenor of all the conversations that are coming in on their phones. They want to know what is my constituency, the people who can vote me in or vote me out, what are they thinking, right? And one of the ways they do that is by listening to what people are saying when they call in, right? So that being said, with immigration, it's very difficult because if you live in California, you're preaching to the choir. Like most, congressmen and women are on our side, but you need a certain amount of votes in the Senate, mostly, and in the House too, for that matter, to pass laws. And it's very difficult to do that when you have conservative states who will not budge on these sorts of changes.
Right. And in fact, in Unshackle, the very first chapter talks about 10 years ago how we came this close to passing a very revolutionary law for immigration, but it never happened. You guys will hopefully read that soon. All right. Next question is does passive activity apply for O-1A, holding real estate and/or stocks? I don't think that's.
So it's not
Yeah.
visa specific. Remember I said it's are you working or are you not working? If you're working, do you have permission to do that work? That's basically it. So if you apply that concept to this question, then absolutely, right? Do you have permission to do that kind of active investment on your O-1? If not, then you can't do it.
Yeah. And I think this is where the next question as well is about, does O-1 come with specific amount of unemployment days, just like H-1B? Aditya is asking that. So they're pretty much the same. They're very similar in terms of these regulations, right? Where they differ is the flexibility.
No, but there are no specific amounts of unemployment days allowed on the H-1B. The only visa that has like a maximum number of unemployment days, the F1 when you're on your OPT and STEM OPT, right? H-1B, you're supposed to be working all the time. If you're not working, then you're not in status, right? I mean, there is a grace period there at the end, but you can't not be working. If you're unemployed, you're not in status anymore. So that's the tough part about our visa system, is that you always have to be working. You can't take a break, right? I mean, you can go on leave, which is a separate issue. You're allowed to do that. So from that perspective, there are no unemployment days for either the O-1 or the H-1.
I think Manoj might have meant, or sorry, Aditya might have meant, does O-1 get the grace period that H-1B gets?
Yes.
The 60-day grace period. Yes. Okay. Jeet asks, what can a current student do to jumpstart his profile for self-petition visas?
So do things like start judging competitions, do peer review on papers, publish papers, start trying to get yourself nominated for awards. Things like that, I think, are probably the most common steps that I've seen students at least take. If not take, then kind of strategize how they can take those steps in the next few years. But if you do that, then you're basically, you're checking off the judging, criterion for the EB-1, right? The authorship criterion for the EB-1, like those are two. And then as you progress in your career, and you start taking on kind of critical or essential roles in your company, then that'll be 3. When you do that, you start making good money. Maybe you can meet the remuneration criteria, and that's 4. So give yourself a head start by doing things that are not reliant on you like excelling within a company, right? Because that depends on the company. The things that you can do are to go out and find hackathons or other competitions to judge. If you enjoy writing, go out and start getting your articles published. Do peer review, those kinds of things.
Just as a follow-up on that, within the Unshackle community, we're going to be providing resources a lot over the next few months to help you build this profile. Because I think that's the trickiest part of O-1 and EB-1, right? Is where do you start? Like most people don't know where to start. And so we'll create databases of judging competitions you can go judge, or places you can go publish papers, and so on. So Anirudh says, once my EB-2 PERM I-140 is filed with company A, and I switch to company B, does company B also need to file my I-140? And did you mention the filing would take 1+ years?
So once you get the I-140 approved, you said filed, but let's say having it filed with company doesn't do anything for you. It needs to be approved, number 1. And then number 2, ideally wait 6 months before you change companies. And the reason for that is if you go to company B and company A withdraws the I-140, you cannot use the priority date that you obtained with that I-140 for future I-140. Okay. So number one, make sure that I-140 is approved. Number two, if you can, wait 6 months. And then number three, yes, the new company does have to do an I-140, not for, so it depends on kind of what you're asking for. Like if you want an H-1B extension and you need an I-140 for that, like an H-1B transfer, you can use company A's I-140 for the H-1B transfer to company B, okay? But what if your priority date becomes current? You cannot get a green card, you cannot apply for a green card when you're with company B if you don't have an I-140 approved with company B. You have to be employed with a company that has the I-140 approval. So the I-140 right now, PERM, which is the first step, takes 1 year plus right now, probably more like a year and a half right now to a year and 3/4. And then the I-140 can happen fairly quickly after that, but call it maybe, 1/4, of a year, right? So that can be almost 2 years. So definitely it's more than a year to get an I-140 approved, which is why, if you can, the national interest waiver would be such a cool thing to have. Because that only takes like a few months, and you can premium process that. It takes 45 days to process.
Awesome. Last question of this session is, Anirudh asks, does O1 allow you to build side hustle, such as working for a company, but also monetizing your YouTube channel on the side?
So the O1 allows you to do whatever the O1 says you're going to do in the four corners of the O1 petition. Okay, so it's better than the H-1B, and the H-1B is kind of very, it's very rigid as to what you can do for the company, right? The O1 is flexible as long as like the work, whatever you want to do relates to your area of expertise, you can do it, but whoever is sponsoring you for the O1 needs to say you're going to be doing that stuff in the petition. Or the other way you can do it is, let's say you have an O1 for a company and they're very rigid about, what they say you're going to do. You can get a concurrent O1 for your own company that run alongside that O1 and then do all of those things under your concurrent O1 visa. So there are certain requirements for that concurrent O1 for your own company to be in place, which is a topic for a discussion for a different time. But in theory, that's something you can do.
Sameer, you've been awesome. Thanks for being so candid and just approachable in the way you answered questions. Thank you so much.
Sure. Thank you very much. Thank you, everyone. Take care. Have a great weekend.
Bye, guys. Bye.
Bye-bye. Bye.